Good morning, everyone, and welcome to today's webinar, hosted by PYA, Rulings and Rules, the latest healthcare news. PYA is happy to present today's webinar on this important topic. You will have the opportunity to submit questions to today's presenters by typing a message into the question pane of the control panel. We'll collect these and address them by email after the webinar. All of our webinars are recorded and released with a copy of the slides after the event. With that, I would like to introduce Martie Ross, Consulting Principal, and Kathy Reep, Consulting Senior Manager at PYA.
Thanks, Laura, and good morning, everyone. Thank you for joining us. Today's webinar is proof there is never a dull moment in healthcare. The topics that we are going to cover have all come into being since our last webinar on June 15th. So in 3 short weeks, we were able to create yet another fabled top 10 list of developments in healthcare. We'll certainly have a heavy emphasis on court decisions handed down by the Supreme Court and 1 federal district court during this time period. Also addressing the 3 proposed rules CMS has published in that period, as well as other updates impacting different industry segments. And we will wrap it up with a preview of what's yet to come here in the dog days of summer. So with that, let us start in with Supreme Court, court decisions, just a second, issued here in the last 3 weeks that are impactful to the healthcare industry. So Kathy, over to you to discuss 340B.
All right. There we go. First case that we're going to talk about, I think, was one of the first ones that we got towards in June from the Supreme Court, and this was American Hospital Association versus Becerra, or as better known, this is the 340B issue. As a little bit of background, we've got to remember that for 340B in 2018, CMS made an arbitrary, we have to say, decision to reduce payments for 340B drugs to those providers who participate in 340B, rather than being paid for separately payable drugs at average sales price plus 6%. All of a sudden, they saw their drugs being reimbursed at average sales price minus 22.5%. So significant drop in payments for 340B drugs to those providers that were participating in the 340B program. In implementing this reduction on 340B, CMS took the supposed savings from this and they added it back into the base rate for all providers, so that we saw a 1.38, I think it was, bump in the base rate. So 340B providers got the bump in the base. The hospitals that are not 340B got the bump in the base. Predominantly for that bump in the base, non-340B, those are going to be a lot of your for-profit facilities, because they are not 340B providers. But everybody saw the increase in the base. 340B providers saw the decrease in their payment rates for the drugs. This went through the courts. It was originally decided in favor of the providers. It was then reversed. It has wound up at the Supreme Court. The Supreme Court decision relates to the years that were raised during the court case, 2018 and 2019. However, that reduction is still in place here in 2022. And I would be very comfortable in saying that the outpatient rule that is currently sitting at the Office of Management and Budget, and probably will be out this week, continues that reduction. But the courts have said that the reduction is not appropriate in terms of the way it was implemented. So we're going to have some decisions in terms of what goes forward, how we deal with this until there's final resolution. But essentially the issue was not that the reduction was wrong per se, but it was how CMS went about setting that 22.5% reduction. The current statute says that in order to set rates, CMS for these drugs, CMS has to either use average acquisition costs or they have to do a survey. And they did not do a survey, and therefore they don't have the ability to use anything other than average acquisition costs, and to base reimbursement on that. So the American Hospital Association, those providers involved in the litigation were successful, but don't look at the money to be paid out tomorrow or even in the next year, probably, because this is going to be a major decision in terms of how it is implemented. I feel comfortable that ultimately it will go through the current year, not just 2018 and 2019. But then we have the issue of, do we satisfy those 340B providers with a lump sum payment using new money, or are we actually going to go through a horrid process of adjusting the base rate and taking back money on claims that were paid as far back as calendar year 2018? If this were to actually happen, this becomes a nightmare because of adjusting all of those claims and adjusting patient liability. And you recognize the need to refund money to patients or to bill patients if they have if their amount of liability was incorrect. So how we address this becomes a real issue. The Supreme Court has remanded the next steps down to the lower courts, but you can recognize that CMS, the American Hospital Association, the Federation, and others are all going to want to have an active role in addressing how this is ultimately resolved. I'm anxious to learn what they do for the outpatient rule this year, if they continue with ASP minus, or if they, and I guarantee you, because the proposed rule has been sitting at OMB since probably February or March, it's been sitting there, so I feel comfortable that they continue to propose the negative 22.5. What will they do in the final rule, which we won't have until November? So going to be interesting in terms of where CMS ultimately goes with this and how they fix the decision now that the court has decided in favor of the 340B providers. The next case I want to touch base on, providers were not as successful. And this is Becerra v. the Empire Health Foundation, and it relates to Medicare disproportionate share payments. The question in this particular litigation was the Medicare fraction for disproportionate share purposes. The formula that is used for a portion of disproportionate share is Medicare SSI days divided by total Medicare days plus Medicaid non-Medicare days over total patient days. So it is that total Medicare days field that is in question, that calculation of total Medicare days. Obviously, Medicare days are inpatient days because we aren't looking at outpatient here. But what happens when I have a patient who is eligible for Medicare, but Medicare did not pay for the services? Perhaps the patient had exhausted their benefits with their lifetime reserve days or something like that. They are still eligible for Medicare, not for inpatient services perhaps, or they have exhausted a benefit within for a period of time until they recoup some of their base days. But the issue is, do we count those who are paid by Medicare, or do we account those who are eligible for Medicare? The decision was that those patients who are eligible for Medicare, even if Medicare did not cover the days, should be counted for disproportionate share purposes. And Supreme Court found in favor of Health and Human Services, or CMS, saying that their interpretation was appropriate, and this was a loss for the providers who had been dealing with this. It is a significant, if providers had been successful, it would have increased overall disproportionate share reimbursement significantly for DSH providers, but unfortunately in this particular case, they were not successful. Back to Martie.
So Marotta Memorial Hospital Employee Health Benefit Plan versus DaVita addressed a federal statute that requires employee health plans, or prohibits for employee health plans, for differentiating in benefits for individuals who have end-stage renal disease from those benefits offered to individuals that do not have such a condition. This is part of the Medicare scheme for transitioning patients from employee health plans to Medicare coverage for ESRD over a period of time. The health plan in this case came up with a clever solution to reduce their costs for ESRD patients by moving all outpatient dialysis providers to out-of-network status, thus resulting in obviously a minimal benefit for any employee on the plan or a dependent on the plan who had ESRDs and required those services. DaVita challenged that practice, saying that one cannot distinguish between an individual who has ESRD and an individual who requires outpatient dialysis services. But the majority of the Supreme Court sided with the health plan, stating that there is no requirement in federal law that a health plan provides some minimum level of benefit for outpatient dialysis. Instead, it simply protected ESRD patients from being treated differently. It is a relatively narrow decision, except when one starts thinking of the consequences of the holding. Are there other opportunities for employers to carve out high-cost patients from their employee health plan coverage, such as high-cost behavioral health issues, high-risk pregnancies, and the like? And of course, other plans following the lead of Marotta Memorial Hospital to carve out their ESRD patients, their outpatient dialysis patients from their health plan coverage. Should this occur, that's seriously going to have an impact on federal programs, both Medicare and Medicaid. Also then a longer term impact on providers who will, instead of having these patients covered by higher reimbursed commercial plans, find these patients on federal programs. And given the current status of the Medicare Trust Fund per the trustee report, this has serious long-term budget implications, as again, we see more high-cost patients migrating off of employee health plans into the federal programs. Next up is Dobbs. This is the case that reversed Roe v. Wade, addressing the federal constitutional right to abortion. The crux of the decision is the Supreme Court, the majority holding that a right to abortion is not one deeply rooted in our history. It is not specifically mentioned in the Constitution, and thus the test to be applied by the courts to determine if there is in fact a constitutional right is to examine whether a particular right has been deeply rooted in history, or is such an integral part of a broader right that is so rooted. And the court concluded, following its review of the law, that there was no deeply rooted right to an abortion, and thus it is not constitutionally protected. Once determined that there is no constitutional protection of abortion, it then defers to the state to elect to regulate abortion to an extent that such regulation serves a legitimate interest. So then the majority evaluated, is there a state legitimate interest to be protected in regulating abortion? And the court concludes that in fact a state a legislative body can determine that the interest in respecting for and preserving prenatal life at all stages of development is an adequate justification for regulation of abortion. And that's where things stand following the issuance of the Dobbs decision. There is a lot of ground to plow over the next several months, several years, regarding the implications of Dobbs, particularly on the healthcare community. Where we stand today most immediately is coming to understand the impact of the decision on both dormant and trigger laws. Dormant laws are those passed by state legislators prior to Roe v. Wade. And if they have not yet been, if they were not removed from the books post-Roe, they remain there. The question is, do they once again become effective? So if you have a 1890 law that outlawed abortion, would it then, and then was effectively struck down or rendered ineffective by Roe, what's now the impact of the Dobbs decision? So we have a round of court litigation already on that issue. Trigger laws are those passed by state legislatures post Roe v. Wade that had a trigger that once the court overruled Roe, those provisions would go into effect immediately or over some period of time. We now have litigation around the impact of those trigger laws and challenges to specific provisions included in those laws. And it's every day you have to get your map out what court has enjoined what action or enjoined an injunction of an action as we identify the status of different state prohibitions or restrictions on abortion. We will soon have litigation around state constitutional protections. For example, in the state of Montana, the Constitution explicitly recognizes a right to privacy, and the Montana courts have held that includes a right to abortion, and that have impacted the enforcement of Montana's state legislative action regarding abortion. So there'll be litigation around the impact of Roe potentially on these state constitutional protections. Here in Kansas, where I reside, for example, we are headed to the polls on August 2nd to vote on a constitutional amendment that would effectively override a prior decision of our Kansas Supreme Court holding a constitutional right within our Kansas Constitution. We will then have a new round of state laws, and these are state laws pointing in both directions. We will have state laws implemented restricting the right to abortion or imposing requirements on those who seek abortions, as well as states that attempt to protect individuals who travel into their states to receive services. And certainly then the response by those states that have restricted abortion that impact then the right to travel and to seek services outside your state. The question of whether there'll be extradition to return patients, to return or inform the home state. Simply, it's a whole debate over what does it mean to be the citizen of the state that's ahead of us. So much to pay attention to here, and we will come back to this issue toward the end of today's discussion as we address the Office of Civil Rights Guidance on HIPAA protections as it relates to the Dobbs decision. Next up is Iran versus United States. This is a overturning of, well, it's not the overturning of a criminal conviction of two physicians, but a remanding to the district court regarding the conviction of two physicians who were accused of operating opioid pill mills. The government argued that the Controlled Substances Act should be interpreted to apply an objective standard to determine whether a physician issuing a prescription, in fact, did so for a legitimate medical purpose. So in these lower court decisions, including the criminal trial, the government argued, and the judge accepted the argument, that one simply looking at the level of prescribing practices from these two physicians, that objectively there could not be a legitimate medical purpose for such overprescription of opioids. on appeal, the Supreme Court determined that in fact you have to apply a subjective intent because this is a criminal statute. It requires mens rea. There has to be a guilty conscience. That's what it means in Latin. And that the court has to demonstrate evidence that, well, I guess not the court, excuse me, the prosecutor has to present the compelling evidence to the jury that the physician at the time knew there was no legitimate medical purpose for the prescriptions that were being issued. So now we will have a remand of this case back down to the lower court to review the jury instructions to determine if they were in fact consistent with such a subjective intention, or if in fact they were premised on the objective interpretation of the rules. If so, there would be a retrial in these cases. So it's certainly interesting in the broader case of medical practice and the criminalization of certain activities, and how the court will, under the Ruan decision, require that evidence of subjective intent, that I in fact intended to do the thing that is prohibited, that I had no legitimate medical purpose in issuing this particular opinion, or I did not interpret I did not engage in action that was deemed to be a violation of law. So this will be an interesting interpretation of the law, especially as we move forward under the new Dobbs world and those procedures. Next up is the decision from last Thursday in West Virginia versus EPA, which I personally think is going to have the biggest impact here in the healthcare world. This was the Supreme Court's decision on the major questions doctrine. So how do you get from regulation of coal-fired power plants to healthcare? It's not a very long walk. This was a case that challenged regulations that were intended to curb power plants' carbon emissions, and these were issued under Section 7411 of the Clean Air Act. That provision in the Clean Air Act, dating back several years, gave the EPA the authority to determine the best system for emission reduction for buildings that emit air pollutants. The Supreme Court, in reviewing these regulations, which in fact are no longer in effect, the regulations had been vacated prior to the Supreme Court's action, but still finding a live controversy, the Supreme Court determined that the major questions doctrine applied, meaning that a federal agency cannot, quote, make decisions of vast economic and political significance absent express congressional authority. So this case, the court said, if Congress had wanted to give the agency the authority to regulate power plants' carbon emissions, they would have needed to expressly state so in the legislation, as opposed to the agency relying on more broad, generalized directives in the statute itself. So what's it mean? Going forward, how will the major questions doctrine be applied to healthcare regulations? Does this become ground for challenging Medicare reimbursement, the manner in which Medicare sets payment rates? Are there opportunities for providers to argue that there is not such authority under the Social Security Act for the CMS to apply certain interpretations and establish certain reimbursement models? Is this going to be a basis for challenging price transparency, both from the hospital view of price transparency as well as the payer obligations, which Kathy will soon talk about, that went into effect on July 1? What about the HIPAA privacy and security rules? As those broaden out and impose more obligations on providers, are we going to see potential challenges saying, no, these go beyond what Congress had directed in the Health Insurance Portability and Accountability Act of 1996? Medicaid funding. Are we going to see states challenging the restrictions that CMS places on state plans in the manner in which they use their Medicaid dollars and what they cover under their programs? Is this an opportunity now to challenge certain Stark Law regulations? For example, the prohibition on physician ownership in hospitals as an overreaching of the authority given to CMS under the original Stark legislation in the Social Security Act. Other laws that you want to challenge?
Martie,
certain major questions is going to open the door. Sorry, Kathy, go ahead.
What about the vaccine mandate?
Oh, sure. Yes, exactly. Is that within the health and safety mandates in the Social Security Act? Or is that within what OSHA can do under its workplace safety requirements? guidance. Absolutely. All of this is opened up now, and we will learn the contours now of the major questions doctrine. The other side of this is just what potential chilling effect does major doctrine have on agencies going forward? Because if you don't like something that an agency has proposed, certainly in your comments submitted to the agency, you'll have the opportunity to raise that this action is beyond what Congress had authorized the agency to do under the interpretation of the Supreme Court of the major questions doctrine in West Virginia versus EPA. Next up is we're actually going to go out of the Supreme Court and head to a federal district court in the city of Huntington, West Virginia. This is a federal district court decision handed down 1 year after a bench trial challenging the liability of drug distributors for the damages caused by opioid distribution. Interestingly, this decision actually came down the evening of July 4th, after a year from the date. But the court ruled that as a matter of liability, that the argument of a state law that prohibits a prohibition on public nuisance could not be used as a basis for liability for distributors of opioids. And so in litigation, this is a win on the side of the distributors. If you have been tracking the opioid litigation at all, and certainly it's almost a full-time job to track opioid litigation and settlements, we have a series of settlements that certain states and municipalities have agreed to with both the producers, the distributors, the consultants, all of these different parties that contributed to the distribution of opioids and the promotion of opioids. The settlements have been favorable in most cases, billions of dollars having been secured through settlements, but cases in litigation that actually go to trial. This case in West Virginia, which was the first involving distributors, cases down in Oklahoma, case up in Ohio, it's more of a mixed bag. And it seems that bench trials don't end as well for the plaintiffs as do jury trials. But this certainly will have a certain impact on future opioid litigation, future settlements. Just to pay attention, a lot of these opioid settlement dollars are now being funded by those parties that settled and finding their ways to states and municipalities. Unlike tobacco litigation, which is sort of a free-for-all, where that money could be used for nearly any purpose by a state legislature. We have a lot of nice roads in Kansas paid for by tobacco litigation, for example. The opioid settlements very specifically require that the dollars be used to fight the opioid epidemic, meaning states are going to have new funds, meaning providers who furnish those services, prevention, treatment, and recovery for opioids may have new opportunities to bring dollars into those programs. So certainly pay attention what's going on in your state with those dollars and look for those opportunities. Enough of court decisions. So Kathy, let's get our bread and butter. Let's talk about proposed rules.
All right, we've got a few rules that we're going to share with you. This is the season of the calendar year rules. Earlier, we had webinars related to inpatient rehab, psych, etc., because those programs are on the federal fiscal year. Now we're getting into the time where we have proposed rules related to calendar year, things that will be effective January 1, 2023. So the first rule that came out that we have is the home health rule. It actually was the first one that was released of the calendar year rules. It came out on June 23rd with comments being due August 16th. We would expect to see a final rule sometime around the 1st of November for an effective date of January 1. Similar to what happened with the skilled nursing proposed rule that came out, even though overall costs and have gone up under the home health program, the proposal is for a reduction in your rates, and it's a reduction of about 4.2%. That should turn out to be somewhere close to $810 million compared to this current year. in terms of reimbursement to providers. Again, like with skilled nursing, the reason for this significant reduction in rates is because they are going through and equalizing expenditures. Home health agencies went on a new payment methodology, a 30-day methodology, as opposed to a 60-day period. We went under patient-driven groupings model, PDGM, and what they have done is they have said, let's look at what we would have spent if we had stayed with the old model and the 60-day time frame for a for home health, as opposed to a 30-day payment period. They've looked at what they would expend there compared to what they're expending now, and they have come out with a proposed 7.69% adjustment to the rates. There's a positive 2.9, there's a negative 7.69. So overall rate reduction of about 4.2%. If you are a home health agency or have one as a part of a system, I think this is something very important for you to take a look at, not only in the impact of this particular provision on your organization, but also to comment in terms of the appropriateness of this. Maybe rather than making this adjustment now, it should be re-looked at in a couple of years. And I say that because of the public health emergency, because of COVID, because of some of the expenditures that were perhaps significantly different during that period. And maybe this really needs to be looking at a normal year compared to prior program. As with the other prospective payment systems so far, they are proposing a permanent 5% cap on the reduction on any reductions in your wage index. If your wage index goes down from period A to period B by more than 5%, you would be capped at 5%. Then for the next time period, you would be looking at your current capped wage index compared to the new one. And again, a limitation of 5% on any decreases. They are proposing to use calendar year 2021 data to recalibrate the weights for the various groupings under the home health program. This is something that, again, I think is definitely worth commenting on, because again, 2021 was not, I would say, a normal year. Is that really a good year to recalculate the weights on? Or should we perhaps be asking them to leave the weights as they are for 2023 and perhaps then wait 2024 based upon 2022? Something to take a look at. An issue that has been raised quite often at the Medicare Payment Advisory Commission, MedPAC, is the issue of telehealth use for home health services, and that it is difficult to know when home health was used for home health purposes because it's not clearly delineated on the claim. So they are proposing to use various G codes to identify the use of telehealth as for home health, and they are asking for feedback from providers on what you think about doing this. Obviously, it does increase the administrative burden of tracking this and billing for it, but it's also one of those issues that having this information will help in justifying, I would think, continued use of telehealth in various situations if we can see and clearly document its use. One thing that I did not include on the slide related to home health is the proposal in this rule to begin reporting all payer, not just Medicare OASIS data, patient satisfaction data, beginning for calendar year 2025. So there would be a couple of years delay in doing this, but recognize that this is a proposal for reporting all payer data. The next proposed rule that we have to take a look at is the end-stage renal disease proposed rule. This came out on June 28th with comments due on August 22nd. I just have to go back to home health and say, very interestingly, the display version of the home health rule was, I believe, 84 pages. The display version of the ESRD rule is a little over 300 pages. So it's interesting that the ESRD rule is very voluminous, but when I look at what they're calling for, it's like just not sure that there's a lot of meat there in that particular rule. But they are proposing an increase in the rates of 3.1%. That would be increasing your base rate to $264 from the current $258. The labor share would be going up. The proposed labor share, this is the amount of the payment rate that is adjusted by the wage index, would go up to 55.2%. That's currently 52.3. So those of you who are in a market with a wage index greater than 1, you would see your payment rate go up, your base rate. For those of you who are in a market with a wage index less than 1, you would see your base rate go down by that calculation of the wage index. Again, they are also addressing the 5% cap on wage index decreases. They did it for inpatient, they did it for skilled nursing, for rehab, for psych. I think this is something we're going to see. You'll know if this is happening for ESRD and home health as soon as we have the first final rule for the inpatient or for the fiscal year, federal fiscal year rules. They are proposing to update the outlier threshold using 2021 claims data. I would expect then to see that the outlier threshold will go up. And finally, on the issue of ESRD quality improvement program, they are proposing to continue to collect certain measures, but not to score them, again, because of the public health emergency. So I think it's kind of interesting that the public health emergency, we continue to say we're not going to use, let's say, quality data, but we are going to use claims data to adjust rates and to adjust weights. So I think it's interesting that public health emergency is still, if I can use the word, an excuse for doing some things, but they don't do everything. I think maybe consistency would be nice. And then Martie, conditions of participation.
Sure. So on June 30, just in advance of the holiday, CMS published the proposed rule with the rural emergency hospital conditions of participation, as well as updates to the critical access hospital conditions of participation. Comments on these rules will be due by August 29. Regarding the rural emergency hospital program, as you may recall, this was passed by Congress as part of the Consolidated Appropriations Act of 2021. It directed CMS to create a new category of a Medicare reimbursable provider. The REH is a hospital without inpatient beds, so it furnishes outpatient services, observation services, and other approved hospital outpatient department services. We have been waiting, not all that patiently, for CMS to publish the proposed implementing regulations for this new program. Last year, as part of the OPS rule, CMS had solicited comments generally about program operations. With the publication of this proposed rule, CMS has addressed the COPS for an REH. It is not addressed in this rule are the payment provisions nor the quality reporting requirements for REHs. Those are to be included in the hospital outpatient proposed prospective payment rule when it's published. What did you say, Kathy, later this week? Kathy and I have a whole bingo board of when proposed rules are going to come out. So we'll see what CMS does, and obviously the payment provisions are going to be critical to launching this program. The good news is, for those watching REH closely, is these COPS are very consistent with what the COPS are for critical access hospitals, with some minor modifications to appreciate the size of operations within REH. For example, there are variations in the governing body's role in credentialing telehealth providers, so ability to rely on another health system's credentialing of providers who furnish telehealth services to an REH patient. Also included in this proposed rule are new COPS. primarily modifications in some areas. There is a new way in which to calculate the distance of a critical access hospital from other hospitals for those CAUs whose designation is dependent on distance as opposed to a necessary provider designation. CMS now defines what primary road means for purposes of these calculations, and also sets up a new process for state surveyors to apply in reviewing those critical access hospitals that are dependent on distance to determine if there's been a new hospital established within a 50-mile radius, the potential impact that has on the continuation of cost status for that hospital. Also, CMS in the proposed rule intends to add a patient rights COP for critical access hospitals. This is another one of those PPS COP rules that was not included for CAUs. So if you remember a couple of years back, QAPI and infection control, which had been historically in the PPS hospital COPs, we saw versions of those COPs added to the critical access hospital conditions of participation. This time around, they're now adding the patient rights COPs. So it's the notification of rights, privacy and safety, confidentiality of patient records, patient visitation rules, and probably most importantly, the use of restraints and seclusion, again, modified from what we see in the PPS COPs to again appreciate the smaller scale of operations within a critical access hospital. Certainly something for which these hospitals should be paying close attention, reviewing and commenting to ensure that the final rule, when implemented, is appropriate for the critical access hospitals. Finally, in this proposed rule, CMS noted its intent to provide a modification to the COPs regarding infection prevention, as well as QAPI, quality assurance and performance improvement, to allow a modification of those rules if you are a critical access hospital that is part of a larger health system, and that health system operates under one unified governing board. There is now a path forward for, rather than the CAW maintaining a wholly separate infection control and QAPI program, that instead it can operate as part of the system's overall operations, and thus, again, simplifying compliance processes for critical access hospitals. Again, interesting opportunity here to go to their definition of health system, which they do require. It is one operated under a single governing board. Certainly, this would be a wonderful opportunity if CMS would extend this towards those hospitals that participate in other types of networks, besides just a traditional, economically defined hospital system. Those clinically integrated systems, recognized for antitrust purposes, certainly seems that we could have an opportunity to comment to broaden out this participation in unified and integrated programs to include those types of networks. That was not a paid advertisement or anything, just potentially my view on how CMS could be more user-friendly toward our rural providers.
And Marty, did you mention July 13th? I did
not. It says up there, why do I have July 13th webinar? Thank you, Kathy. Kathy and I appreciate it is the busy season, so we're going to go off of our every other week schedule for Healthcare Compliance Roundup webinars. So we will tackle and do a deep dive into the REH-CAW conditions of participation. So we expect, because the outpatient rule will be out later this week, we will also address the payment and quality provisions. In a webinar a week from today, on July 13th, we'll have the registration information posted on that webinar later today to address for you all. Thanks, Kathy. Almost forgot.
No problem.
So I put it there in the heading so I wouldn't forget. Oh, good. You get to talk about transparency and coverage.
Yes, let me talk very briefly about transparency and coverage. I think those of you representing hospitals and even some physicians, because you've heard the moans and groans from the hospitals you work with, are familiar with the pricing transparency requirements that went into effect a year ago. Well, there are also pricing transparency requirements that are applied to the payers. And the first round of this was effective July 1, last Friday. It had originally been delayed. It was originally required to be in effect January of this year, but there was a delay. in the requirement on the payers. So we now have official go live. Payers are required to post machine readable files in a JSON format, required format, that essentially shows the in-network provider rates and the out-of-network allowed amounts. Now, recognize that these are huge files. And this is not just on a payer per se, like a Blue Cross, but it's also on those employers that are self-insured. So they have huge files out there. We're talking massive data. I actually read a blog earlier this morning from a vendor who began at midnight, June 30th, monitoring what was being done in terms of compliance and looking at who's coming on. I mean, actually going in and looking at payer after payer, large employer after large employer, to go in and identify if they were posting, if they met the requirements for posting, etc. But it seems that they are moving along fairly quickly in terms of getting the data posted. But again, it's not really searchable data. It's not like I can go in and look at my insurance and say, what is my out-of-pocket liability going to be if I go here versus if I go here? That's not there. It is merely this massive file of a particular payer's negotiated rates under each of their individual products with various providers. So it is out there. They are starting to post. There is a penalty for non-compliance for the plans. I think this is a little bit stricter penalty, I would say, than the penalty for providers. Providers, the maximum is I guess it's the $5,500 per bed, which is a little over $1 million or $2 million. But for the payers, it is $100 per day per member for non-compliance. So the slide doesn't have the per member thing there, but it's $100 per day per member per plan. So if you offer 5 different products, your penalty could be significant if you are non-compliant. In 2023, the payers, this would be January of 2023, the payers are expected to have an internet-based price comparison tool that would actually allow the consumer to go in and identify what their cost sharing is going to be based upon making a determination of where they want to go for services. That is not a requirement yet, but we'll be monitoring to see when that does come out. So back to Martie. Okay, we lost Martie there for a minute. This is new guidance that has come out related to Surveyor Guidance for long-term care facilities. This isn't long-term acute care hospitals. This is long-term care facilities, think nursing homes. And it does impose requirements on state surveyors for timely investigation. I think this has been an issue in the past where there might have been reports, but investigations did not happen. And therefore there was additional abuse that perhaps and neglect was not addressed timely. There is going to be a requirement for the survey to use the payroll-based journal staffing data to confirm compliance with nurse staffing requirements. There are minimum staffing requirements that are going to be coming out. Once that comes out, then the surveyors are going to have to use that data to make sure that the provider is in compliance with those staffing requirements. Their facilities are going to be required to have on-site infection preventionists, at least on a part-time basis, and they are going to be required to have the background and the education to oversee infection prevention and control programs. The facilities are going to be limited to only being able to have single or double occupancy rooms. They are not going to be able to have a dorm type environment. And then finally, the Surveyor Guidance addresses the various rights of and behavioral health, the rights of and the required services for individuals with mental health needs and substance abuse disorders. So this was included out there in that Surveyor Guidance that was recently published. I'm still looking for Martie, but she's not with us. June 27th, there she is, Martie.
I'm back. Sorry.
Okay, I did the Surveyor Guidance. Do you want to do oncology?
I would so love to do oncology. There we go. I apologize, everyone. I think it's the heat. That's my extent right now. The heat is impacting the internet. Internet. Okay, on June 27th, the Center for Medicare and Medicaid Innovation introduced a new alternative payment model, the Enhancing Oncology model. This is based on its predecessor is the Oncology Care model, which had launched back in 2017. In 2017, it finally came to a close on June 30. And so this is the next version of the OCM. You guys see here the link to the website where CMMI has posted all of the relevant information, including the request for application, which details all of the program requirements. But broadly speaking, this is a specialty-specific episodic payment model. It is voluntary, so this is not like the ongoing dispute over the radiation oncology model, which would have been mandatory for certain providers. This is still a CMMI model where you have to submit the application and be accepted into the program. This is focused on episodes of chemotherapy administration for the specific cancers you see listed here. And like any episodic payment model, there's a benchmark for the episode. And if you beat the benchmark, you will retain that additional savings. And if you are above the benchmark, you will have liability owed back to CMS, the difference between the actual total cost of care and the benchmark amount. There are quality measures that certainly come into play that will result in adjustments to those payments, as well as appropriate loss ratios and caps on amounts that can be received under the model. Note that unlike OCM, its predecessor, EOM is at risk from day one when you enter this program, which is scheduled to begin September 1 of 2023. Also note that this program for its participants requires that oncology practices engage in certain defined redesign activities intended to enhance communication between the oncology provider and the patient primarily. Those activities, those enhancement activities, the costs associated with them can be offset by a participating practice by submitting claims to what's referred to as the monthly enhanced oncology services payment. So during the episode, you have this opportunity to bill $70 a month for purposes of covering those operating costs. That amount's increased to $100 for any beneficiaries who is a dual eligible beneficiary. The reason it's considered optional is because the amount of the MEOS is included in the total cost of care, meaning that if you're billing for this, you're increasing the total cost of care, which is pulling you further away from the benchmark, and thus increasing your risk of having to make a repayment, or more optimistically, reducing the amount that you'll receive as the episodic payment opportunity. So certainly a lot to learn here. We've just posted to our website a summary of the Enhancing Oncology model and can provide more detail for you. And we're still looking to see more alternative payment models coming out of CMMI following the reset that they published last October. Hopefully this is the dam beginning to burst on these opportunities moving forward. Number 8 is something that almost missed my watch, was a request for information that was issued by HHS, the Office of Assistant Secretary for Health. So not CMS, this is coming out of OASH. It was published in the Federal Register on June 27. Comments in response to this request for information are due by August 1. So this notice introduces a new HHS initiative to strengthen primary health care. And the intention is for HHS to delineate those specific actions its agencies and office can take within current legislation and funding environments to enhance primary care. So absence any congressional action, new statutory authority, new funding, what can HHS potentially do that will enhance primary care across the United States? So what they are seeking in this request for information are examples you can share with them regarding successful approaches and innovations that can improve primary care, new delivery models, new ways of educating primary care providers, enhanced training, support for the well-being of providers so they don't leave the industry, and what are the opportunities for better use of digital health, and how can we better measure and research primary care to enhance the delivery. I think that's about as broad as you can get in terms of the comments that the agency is seeking as it develops this broader initiative to address primary care across all of its agencies and offices. Number 9 on our top 10 list is OCR Guidance, recently published, beginning with the use of remote communication technology for audio-only telehealth that came out in mid-June. This is OCR, the Office of Civil Rights, the agency responsible for the enforcement of HIPAA privacy and security, providing advice to the industry on primarily HIPAA security rule issues related to audio-only telehealth, noting this guidance becomes effective at such time that OCR's prior notice of enforcement discretion regarding telehealth during the public health emergency is no longer effective. So this is OCR preparing for the day that the PHE ends and it revokes that prior notice, which effectively gave us all a pass on HIPAA privacy and security rule posting on telehealth during the PHE. It is an interesting read. Remember, landlines are not subject to HIPAA, in case you've forgotten that from the old days. But all of these new voice over internet and other protocols for audio-only communications are subject to HIPAA privacy and security. And it's a reminder of your obligations to ensure the security of those communications. Although this is focused on audio-only telehealth, certainly the advice OCR is giving here would be applicable to audio-visual telehealth, as well as provision of virtual services using these other communication-based technologies as well. Then on last Thursday, before the holiday again, OCR released 2 new guidance documents. The first regarding disclosures of information relating to reproductive health. This is in response to the President's guidance to federal agencies to do what they could to protect or to provide access to abortion following the Dobbs decision. This guidance specifically addresses the HIPAA rules regarding disclosures of health information as required by law for law enforcement purposes and to avert a serious threat to health or safety. So there's a review of those provisions in the HIPAA privacy rule and the application of sharing information relating to reproductive health. Finally, the third piece of guidance, which is actually directed to the consumer world, not the healthcare world, is how to protect the privacy and security of your health information when using personal cell phones or tablets. Reminding again that HIPAA does not protect PHI that's used by consumers, that PHI restrictions within those rules applies to covered entities. And not to us covered entities and business associates, not to the average citizen. And so there's actually very detailed advice on how to turn off location services on your cell phones, whether it's Android or iPhone, that's contained within this guidance. And you see there the link to all 3 of these guidances on the OCR website. So I have concern there. You know what, Kathy? I realized during my internet blackout that something else has happened in this 21-day period since we last convened, which is July 1 is when sequestration went back to 2%.
That's true, very true.
So providers for those services that you have furnished after July 1, you are getting 1% less in Medicare reimbursement. And we still don't have a solution out of Washington to the BAGO nightmare which means that effective January 1st of 2023, absent congressional action, we're going to see a 4% cut in addition to the current 2% cut. So 6% total, effective January 1. So certainly that's a legislative priority for all of us moving forward. But Kathy, what else are we watching these days and getting ready for?
Just to get to number 10, so that you know, I think those of you who were wondering, will these two ever run out of things to talk about? The answer is, of course not. We do have, and Marty and I are predicting that this afternoon we will see the proposed rule for the physician fee schedule. Marty threw out some things here that we expect to be included, but this is going to be obviously the conversion factor. What is the base rate, telehealth issues, virtual services? One that is not on this list, but that is always my pet peeve, is appropriate use criteria. And AUC is probably going to be included in this rule, and it might be the only positive thing in this rule. She says, hint, hint, hint. We'll see. Stay tuned for a future webinar. The outpatient hospital rule, which also includes the ambulatory surgical center rule, that would be a proposed rule also coming out. We vote by Friday, but we'll see. We already have some of the fiscal year 2023 final rules sitting at the Office of Management and Budget for review. We do know that psych and rehab are there. We should be seeing SNF and inpatient coming soon. The sooner they are posted tells you how much attention they paid to your comments. If they're posted a week after comments were due, they probably didn't listen. But we'll see what happens there. There is a notice, not a proposed rule, but a notice regarding the requirements for an advanced EOB. This is under the No Surprises Act. We're kind of trying to figure out what would be included in a notice because it is not a proposed rule. We don't really know how they would be implementing AEOBs because we don't have any good transaction standards for it. So maybe this is just a notice of a further delay in the AEOB. Marty has her fingers crossed, so we'll see on that one. And then finally, there is under the Department of Labor a final rule related to surprise billing part 2. Remember what we had before? It was an interim final rule and people made comments. Part 2 is going to address the dispute resolution process and it's going to address good faith estimates. I vote that most of this final rule will be on dispute resolution, but this one should be out. It is sitting at OMB. It requires you to look when you look at the OMB what's been posted for review. You got to look under the Department of Labor, which is actually listed as Labor Department, not Department of. So it is one of those things to keep an eye on. But expect that you will be seeing additional webinars from us on all of these topics. I don't know if that is a good thing or a bad thing, depending upon those of you who are faithful listeners. Finally, just a couple of things coming. I'm sorry, I jumped the wrong way. Our next roundup is going to be on the Rural Emergency Hospital Program and the cost COPs. This is going to be next Wednesday, so stay tuned. And as Marty said, we will try to bring in anything from the outpatient rule that applies to this particular program as well. But then we'll do a separate webinar on the outpatient rule eventually. And last but not least, we wanted to mention that we are, both Marty and I are involved in this from a speaking perspective, but PYA is offering a summer CPE symposium, What's Hot in Healthcare. This is going to run over 2 days, July 27th and 28th. And there will be eight CPEs available for this. If you go to our website, you will see the detail and the information to register, but we think that this is going to be a great opportunity for folks to come together and have more insight into what all is happening. And with that, Marty, any closing words?
Just an apology that we did not offer CPE for this webinar. We were kind of up against the timeline and didn't have the opportunity to clear all the CPE hurdles. We certainly try every time we can to offer CPE for these sessions, but thank you for joining us today, despite the fact we did not have that little food pellet to reward you with. And we will see you next week.
Take care.
Thank you. Thanks to our presenters, Martie Ross and Kathy Reep. If you have any questions, their presentation and contact information will be emailed to you, along with a recording of today's webinar. Also, if PYA can provide assistance with audit, tax, compliance, valuation, or physician services, please call or email us. You may also visit our website at pyapc.com for more details about our specific areas of expertise or to subscribe to receive PYA insights. Please remember to stay on the line once the webinar disconnects to complete a short survey. On behalf of PYA, thank you for joining us and have a great rest of your day.